Part 2, family. Part 2. Pick back up. UK. In the United Kingdom, senior public appointments are made by warrant under the Royal Sign Manual. You hear that? Under the Royal Sign Manual. If y'all don't know what that is, I need not to even explain that to you. Y'all need to look this stuff up, UK. Because I'm not talking about over here in America. I'm talking about y'all. Look this stuff up, the Royal Manual. Yes, they do have one. They have that manual. Go look this stuff up. Royal Sign Manual. Look this stuff up. The personal signature of the monarch. You have to have these seals, family. Go look this stuff up. It's in your books. It's right there in your manual. You better go look it up in lieu of your warrants. Because they're still in your houses over there too. And don't say they're not, because they are. Because I got several UK individuals hitting me up. And they're donating for the documents in lieu of what they're doing. And getting the basic and general information that can be used and matched with using over there. It can be. You just got to find your statute, find your codes, find your statutes at large and things of that nature. You have them over there. So it said a personal signature of the monarch. You notice why I say personal? Not just anybody. You feel me? Not just anybody. It said the personal signature of the monarch. And I'm pretty sure the UK, y'all know what it is. What's a monarch? You feel me? So it say on the recommendation of the government. And in an interesting survival from medieval times, these warrants abate, lose their force on the death of sovereign if they have not already been executed. This particularly applied to the death warrants in the days when England authorized capital punishment. You hear that? Perhaps the most celebrated example of these occurred in the 17th day of November 1558, when several Protestants heretics were tied to their stakes in Smithfield, and the firewood bundles were about to be lit when a royal messenger rode up to announce that Mary I had died and that the warrant had lost their force. See, when you start learning this old stuff, you taking it back to its original creator, how all these warrants came about. You follow me? UK? You take it back. You go right back and you start tracing how these warrants came about, how they had to start having signatures and seals. Yes, they still are required. They're still required to have them. So I'm just taking it back to y'all. I had to go all the way back because a lot of times, like I said, UK is stuck under old, they're stuck like under old linguistics that we don't old language that we don't speak of over here. Some cities and some towns, some Commonwealth cities and stuff like that, towns, some of them do stick with a language like constables and things of that nature, but UK is stuck with a lot of old language. So I'm gonna move on. It said the first formal act of Mary's successor, Elizabeth I, was to decline to reissue the warrants, and the heretics were released a few weeks later. So just breaking down the foundation in lieu of a warrant over there in UK, and this foundational, from whence it came. Okay, United States, for instance, it say the history. For many years, English, later British government had used a general warrant to enforce its laws. These warrants were broad in nature and did not have specifics as to why they were issued or what the arrest was being made for. A general warrant placed almost no limitations on the search or arresting authority of a soldier or sheriff. This concept had to become a serious problem, a serious problem when those in power issued general warrants to have their enemies arrested when no wrongdoing had been done. So basically what that saying was, in the parliament, under the British monarchs and English monarchs, they had to change the language in regards to general warrants and things of that nature, because it never made the specifics in lieu of a warrant, like saying when a judge write out a warrant, he tells the specifics who the warrant is for, upon which property it's for, what specific place it's placed on. So those are the specifics, because it makes clearly what this warrant is about and who it's for. You follow me? So that's what it had to do. It had to go under Parliament's change. Had to go about a change for them to change, like here in the United States of America, it gets direct in its specifics what warrants is for. It's specific warrants and who they're going after. Because you can't just file a warrant and it don't tell you who they're going after, what people, place, or things. It gets specific. What place, what thing, and lieu of what nature it needs to be, this thing needs to be seized. So it changed, it makes it specific. So it say the Parliament of Great Britain passed the Revenue Act in 1767, which reaffirmed the legality of the writs of assistance. See, these are old things that were sheriff's rights, but it's changed its language now. But I'm pretty sure they have a language over there in the UK and things of that nature, you know, that it still has the names. See, because we have different redundant names too. It means the same. Like sheriffs over here in the United States of America, a sheriff might write you out what you call a writ of levy. A writ of levy. And he might write you out a writ of garnishment. He might write you out a writ of possession. He might write you out what you call writ of execution. Guess what? It's the same thing. It's giving them the authority to come take something from you. It's the same thing. It's just under being redundant. It's just under a different name. That's all. So that's how it is here, you know, under Parliament, where it's called writs of assistance or general. It says a search warrant. It's a search warrant. And gave custom officials broad powers to search houses and businesses for smuggled goods back then. Which is still the same thing as right now. This law was one of the key acts of the United Kingdom, which led the American Revolution, and is a direct reason that the American founding fathers ensured that the general warrants, once again, would be illegal in the United States by ratifying the Fourth Amendment to the United States Constitution in 1791. See, family? You see the reason why warrants, that Fourth Amendment is bad. Huh? That Fourth Amendment, family, is bad. But guess what? Nobody's using it. Nobody's using it. But I surely am. I got several documents in lieu of the Fourth Amendment by using it and enforcing it. That's why they're trying to cauterize it. They're trying to cut this thing down, trying to stop you from being able to use it. By creating their own rules and regulations, these judges, these magistrates are creating their own rules, operating under their own authority because they think they got some immunity. No, they have no immunity. They think they do. That's just because you're not in your proper status. Then you can go after them as, you know, in their proper person. As a man, you can go after them, you know, as well as their official capacity. You know, so this is the reason why they do what they do. Because they're coming at you as a fiction. And they're giving you these orders that's in lieu of a fiction. That's why they do what they do. You got to get in your proper person. So, family, I just wanted to read this out. I ain't going to even go too long on this video. So it said right here, practice. Under the Fourth Amendment, the United States Constitution, a warrant is broadly required, which particularly describes the place to be searched. Remember I told you it made it specifically. Now, the warrants were brought over here in America. It started in England first, though. History, a lot of history hides that. All this stuff started in England first and made its way to Britain and over here in North America. You feel me, family? The Fourth Amendment. And it gets specific in nature on these warrants. So it said a warrant is broadly required, which particularly describes the places to be searched and the persons or things to be seized. And no warrant shall be issued but upon probable cause supported by testimony before a judge. You see that, family? You see that? So if a judge, i.e. a magistrate, is even given an order, i.e. a warrant, guess what? Family, it's telling you a Fourth Amendment right here has to be supported by his testimony. His testimony is under an affidavit. He got to swear to it. Guess what, family? They're not doing it. They're not doing it because you know why they're not doing it? Because you're ignorant. It's the people that's ignorant. They're not using the laws against them. They're not studying this stuff. They're not studying this stuff. Family, I got sheriff packages. I got the sheriff package A, B, C, and D. Got to start donating for this stuff, family. Educate yourself. Arm yourself and bang back. You don't do this, they're going to continue to keep coming. Arm yourself, learn this stuff, and bang back at these sheriffs. Stop these people at the door. Stop the judge at the door. Stop the sheriff at the door, because this is how they get your house. This is how they get your house. I start demanding for this. I make sure I get a copy of the sheriff's oath and bond. Go ahead and violate me. You ain't got no proper warrant, I'm going after you. Oh, I will file claim against your bond. That's really easy when I got it. Oh, I'm going after you because you can't operate anymore. So I want y'all to know when they got oaths and bonds and you got a copy of that, whoo, man, you're like a Mack truck then. They can't work no more. They can't operate no more. You file a claim against it and watch what happens. Watch what happens. That case becomes like a Mack truck, especially when it becomes an invasion of your privacy and liberty. You feel me, family? They take your house illegally because you need to start doing your homework. That's why you need to learn this stuff. I'm getting the emails. Look, I can't help you if you can't help yourself. I can't help you if you can't help yourself. You're not willing to study this stuff. I did my own homework and done this stuff. You got to do yours. You don't want to do it? Donate for the information. I done my homework. I done mine. Just like when you went to school and learned to be your occupation and what you do to get paid, I done mine. You want to be compensated for what you've learned. Family, I done my homework. You better do yours. Because if you want to take a shortcut, like you be helping like people you educated in your learned studies, and you helping particular companies make them thousands and hundreds of thousands of dollars, these Federal Reserve notes, family, I'm entitled to being compensated. So when I ask for donations, family, not only are you helping me, but you're helping yourself, as well as helping me to be able to further this disinformation. This is serious, because I don't have to do this, or I own some businesses. Believe that, family. I don't pay taxes, family. I don't have to do this. I do this because I love my people. I do this because I have to, but at the same time, family, you will donate for my time. You will donate for my time, family. You will. You will. I have a right to this. And not only do I have a right, I should be compensated, family. Giving you this information, but I'm giving it to you. I'm telling you this stuff to ask for. I'm giving this stuff all to you. You just if you want to donate in lieu of you don't know how to write particular things, I could take care of that for you because I have those things. Then you can donate for them and ask, and then you ain't got to learn this stuff. Well, you do have to learn this stuff. You just get the documents and you study this stuff. You stand on this stuff. You learn this stuff. You become the document, because it's not just the document that's the silver bullet. You become the bullet, because what good is the tool if you refuse to use it? You got to start using this stuff, family. I'm giving this stuff to you. But if you got the tool, what good is carpentry? What good is carpentry if you don't know how to use the tool? How you gonna build the house if you don't know how to use the tools? What good is you building the house if you don't know how to use the tools? The tools is there to study. Study. Now you know how to use it. But, ain't nobody learning this stuff. Don't nobody want to study this stuff. So, but here it is though. Let me move on. Okay. It said the court has recognized many exceptions to the warrant requirements, including exceptions for routine administrative and inventory searches made under exigent circumstances, and searches made with consent. And I had explained that to y'all in my other videos in regarding when they start illegally, not illegally, but they search your car because you allowed them to search. When they ask you, they say, yeah, you can search. Then they go find your marijuana, and now all of a sudden you want to come crying to free inhabitant. Don't come to me. You're guilty. I can't help you. I can't help you. Don't come to me when you got your marijuana in plain view sight. That's right, because it's lawful. If you got illegal guns in what you call plain view sight, don't come to free inhabitant. I can't help you. I can't help you because you shouldn't have had it in plain view sight. I can't help you. You're doomed. You're doomed. Shouldn't have had it there. Shouldn't have had it there. Because if you got a gun that's in plain view sight, hey, they got a right to open that car door up now. They got a right to draw their gun on you. Why? You got it. You become a hazardous now. They don't know whether you got your permit. You or something like that. If you got your permit, first of all, your gun should be in a concealed possession box somewhere in your car if you got a permit, if anything. But it should not be exposed to where they can see it. You should not have this marijuana exposed to where they can see it because it's in clear view, which is called plain view sight. They have that right to do that. Yes, they do. You don't need no warrant now. They don't. And you're getting it from me, firsthand knowledge. They don't need no warrant. They could go in your car. They could grab your behind out your car and search your car. They don't need no warrant. If I see your gun in plain view sight, they don't. You got a bag full of marijuana, half a pound of marijuana or whatever, they can snatch your behind out that car and arrest you and search your car. Yes, they can. But those are the only exceptions, or you allow them to. It's called consent. I can't help you if you consented. I can't help you. I had one of the brothers told me, he emailed me telling him he let the cop search his car and it went on and got ugly with some other stuff. And I can't help you. I can't help you, fam. You're allowed to search. I can't help you. If what you call the fruits of the forbidden tree, if you consented to the consent and they go searching and they find other things, family, that you are not supposed to have in that car, fam, I can't help you. You're doomed. So let me move on. It said a typical arrest warrant in the United States will take the approximate form of this court orders the sheriff or constable to find the named person, whoever he may be found, and deliver said person to the custody of the court. Generally, a United States arrest warrant must contain the caption of the court issuing the warrant, the name, if known, of the person to be arrested, the offense charged, the date of issue. Remember I told you when they're giving these warrants, family? It says it right here. The date of issue. We got three lawsuits where they gave orders. There's not a date on them. I mean, the official ombudsman who worked for the state said was like, wow. He said it himself. This is illegal. It's illegal. There's no dates on these orders. He said, this does not have dates. We said, thank you. This is why we're here. We're trying to explain to you that these magistrates made illegal orders. He just said, come with us. We're going to take care of this because this is illegal. Right there. You cannot give no order, i.e. no warrant, without these prerequisite things put in place. And there's more things other than just this that they got to have that they don't even have. Like I said, you donate for that and you'll have all those things. I got the sheriff pack. It's called the sheriff pack, A, B, C, and D. It teaches you all that you need to know. It gives you affidavits that's in there. You file it against to the sheriff department with the sheriff department in lieu of educating them what they're supposed to have and not have, and you take it from there. You're not only teaching yourself, you're teaching them. So I have these documents called the sheriff pack, A, B, C, and D. You donate for the sheriff pack, and you having foreclosures, you donate for that. You donate for whatever you may need. You want to learn how to get that sheriff oath and bond, you'll get that pack right there. That affidavit right there will come to attachments. I'll send you attachments with that to show you so you'll be sending with that along with a copy of our attachment showing them that if this sheriff department that's of the United States giving it to us under local Open Public Records Act and lieu of Freedom of Information Act, you must give them. So the affidavit is specific in nature. It shows them what we're requesting and demanding for. So you feel like you need to donate for that? Look in the description box, and my email is below this video, and send me an email, and we'll take it from there. Okay, let me see where I'm at here. It says right here, generally a United States warrant must contain the caption of the court issued to the warrant, the name, if known, of the person to be arrested, the offense charged, the date of issue, the officers to whom the warrant is directed, and the signature of the magistrate. You hear that? There it is again. There it is again. It popped up again. And the signature of the magistrate. You see? You see? They gotta have signatures. As I told you before, in the first video, I told you the magistrate can sign a warrant. A court clerk can sign the warrant too. There's nothing wrong. She can sign it. She can sign, either or can sign it. But the court clerk got to seal that document. You got to have that seal. You got to have that seal. So I'm just showing you that other than that, the magistrate will seal those documents. They got to have them, and they're not signing them. They're not signing them. I've received documents from people as well as our own where sheriff typed their name in it. That is illegal. I beat that case. I helped someone beat that case over there in South Carolina. That is illegal. You give illegal garnishments and orders in lieu of trying to garnish someone's bank accounts. You typing your name up on a writ is illegal. And I done gave y'all the information that shows and proved that it's illegal. They typed it up. This says you got to sign your signature. You got to sign your signature. And it must have all the prerequisite attachments under oath of affirmation. You must be swearing to this warrant as a true and correct, and they're not doing it. That's facts. Warrants may also be issued by other government entities, including legislators, since most have the power to compel the attendance of their members. When a legislator issues a warrant, it is called a call of the House. There it is right here. It is right here. The person being investigated, arrested, or having their property seized, like your homes, pursuant to the warrant, is given a copy of the warrant at the time of its execution. They have to have all the prerequisites. They can't just bust in your house, take your house, and then come back and give you no warrant. That's not the way it works. They got to make sure you are properly served. Properly. It got to be handed to you even before they start even taking stuff. Yes. Even before you take my body. You got to say, ho, I'd like to see that warrant of committal, family. Let me see that warrant of committal, Sheriff. Let me see it. No, you're trying to lock me up in lieu of some order that was handed down already, which was committed already. So I need to see the warrant of committal that will allow you to commit my incarceration. It's called a warrant of committal, family. They got to have it. They got to have it. It says it right here, family, and I'm going to break that right here, show you right here. Types of warrant. Arrest warrant. Issued by a judge to detain someone. Right here. Warrant of committal. Bam. Issued by a judge ordering enforcing a previous order against an unincorporated person or corporation. Right there, that's ambiguous, family. When it say uncooperative person or corporation, that's ambiguous, because when you're a person, you still a corporation. So when it say person or corporation, it's still one of the same. So it's being ambiguous right there in language. So A person is a corporation. If it says natural before it, then you're no longer a corporation. You're a natural person, i.e., which is the lawful word, you're a man or a woman. So it say right here, warrant of delivery, civil writ. It's a civil writ issued by a judge ordering property delivered to a named person. Right here, where we got in the U.S., United States of America, warrant of execution. Writ issued by a judge allowing law enforcement officers to seize property. Remember I told you they all are redundant? They all are redundant when I was explaining to you. He'll give you a warrant of execution. He'll try to come at you with a warrant of possession, or maybe a warrant or maybe a writ of levy. You feel me? Or writ of garnishment. It's the same thing. It's a warrant to take something. It's the same thing. It's the same thing. Except it got to be signed under signature and seal, family. So right here, I'm doing your homework. You better study this video. If you looked at it now, if you want to learn more and more and start writing this stuff down, look at it again, and look at it again. Listen to it again, write this stuff down, look at it again, and again, and again, and again, until you get this stuff. Write this stuff down. Right here. Execution warrant. Writ issued by a judge authorizing. See, this right here is a different type of warrant. This is the death of someone. So what they do is they transforming or transferring the word warrant and placing it in the back of execution, which means a death, something you're death. You're writing a warrant to someone's death. They're being put to death, like someone being murdered. You murder someone and you were ordered under a magistrate's signature by the court. It would be a execution, what you call a writ of execution of warrant. That's to put you to death, to kill you. It could be by way of a lethal injection, and or which they outlawed, but a few states probably still have it still, if I'm not mistaken. What you call where they put that thing over your head and they blow your brains out. But a lot of times now they do you lethal injection. So that's what they're doing now. They no longer put that thing over your head and fry your brains out. Okay, so warrant of possession. And Australians right here, over there, right here, y'all have warrants too. Australians judge orders to terminate a resident or real estate tenancy. That's what you call a warrant of possession. So when they're terminating, so where they're no longer going to take something, they will write out a warrant of possession or whatever, in lieu of they're going to take it or they're going to release it. Then you got the possessory warrants, a civil writ issued by a judge ordering property delivered to a named person. So they're going to give you, what you call possessory warrant. It's going to be wrote out in your name. So they're giving you the property, in lieu of a warrant. It's being transferred over. So you got the search warrant, writ issued by the judge, allowing law enforcement officers to look inside a property. That's the warrant. But it would be specific in nature. It'll break that down for you and tell you what places to be searched and specifically where at it'll be searched and whose name it has to be lodged on that specific documents that they're searching for. Because when you got a warrant for a particular place, they can't go directly all over the house unless the magistrate specifically state that in the document, in the warrant. They can't go all over the house. They can't. And I'm telling y'all that now. It's if the magistrate state that in and on the warrant specifically, then the enforcement officers, they can do it. But a lot of times when they have warrants on a specific person, you follow me, in lieu of a warrant for a house search warrant, a lot of time it don't say the whole house. It'll say specifically for that person's room or something like that. Closets, his room, in regards to his particular room, in his closet, or bathroom or kitchen. It'll state what part of the house that the judge will state what part of the house he want you to search. So it's specific in nature. So it says right here, see also arrest warrants of 11 April 2000 case, a warrant canary, a method used by internal service provides providers to inform their customers that the provider has not been served with the secret government subpoena. Now I know all the Moors, we all use this right here, so and I'm pretty sure all the Moors y'all familiar with what you call qua warranto right here. Qua warranto right here. It's a writ requiring the person to whom it is directed to show what authority that you're operating under. They have for exercising some right or power or franchise they claim to hold. So the Moors are we use this terminology right here, qua warranto right here, qua warranto right here. This is what we use right here, what we want to demand. What jurisdiction or authority that who gave you the authority to operate under the way you're operating in this particular capacity? Who gave you that? So that's what that is right there. It's mainly about. So okay, okay. The rest is in regard to treaty. So I'm gonna end that out right here in this video, family, and I'm gonna cut this short. Cause I done did what I had to do. I brought my facts in lieu of this particular case right here, in lieu of order warrants from the courts. You know, is order warrants required by the courts required to be properly signed under signatures and seal? And again, and are attorneys required to file a foreign registration statement? So family, if you like this video, give me a thumbs up. Family, give me a thumbs up. If you like the video, you haven't subscribed, subscribe. I'm bringing the knowledge, the information. I'm banging it back under love, truth, peace, freedom, and justice. You know what I'm saying? And we will continue to keep these things justice here in court and out of court. Okay, family, stay tuned in for something new and something funky that I got coming. All right, take care. Love, truth, peace, freedom, and justice. Peace.